ESG Decoded. I'm your host, Kaitlyn Allen, and today I'm super excited to have two members of the American Bar Association, and we're going to be talking about model contract clauses to protect human rights. So you might have heard the Chancery Lane Project episode, which was a similar idea of model contract clauses for environmental issues. This one is today is specifically about protecting human rights. I'm super pleased to have Susan Maslow and Patrick Miller here. Welcome.
Welcome. Thank you for the opportunity.
Absolutely. And I'll just share a little bit of background on each of you, and then we can get right to it. So Susan Maslow is a co-founder and partner of Antheil, Maslow MacMinn LLP. She is vice chair of the working group to draft human rights protections in international supply contracts, the American Bar Association, or ABA, Business Law Section, and chair of the ABA Business Law Section's Corporate Social Responsibility Law Committee. Sue concentrates her practice primarily in general corporate transactional work and finance documentation, including stock and asset acquisitions, mergers, distributorships, software services, development and licensing arrangements, and business separation. She is a super lawyer, according to Philadelphia Magazine, and all kinds of other incredible awards, which are too long to list for this podcast. We also have Patrick Miller, who's the founding attorney of Impact Advocates, a law firm focusing on international commercial dispute resolution through arbitration, mediation, and litigation. It also assists companies to implement responsible supply chain frameworks. He's a strong advocate for social impact businesses and passionate about assisting these companies when they encounter commercial disputes. He is involved in the business and human rights legal community and recently began working with an ABA Business Law Section working group that's developed a comprehensive set of contractual provisions to address potential human rights violations in international supply chains. And that's why you two are here today. So really happy to have you both, but just a quick disclaimer. Both of these folks are practicing attorneys, so at their request, I will say that none of the information that they are giving today should be considered legal advice, and that's true of all of our podcast episodes, by the way. You may connect with Sue or Patrick directly if you'd like to have legal advice on any of the topics we discussed today. So with that said, welcome to the podcast, Sue and Patrick. So we're talking today about model contract clauses, or MCCs. Is that right?
Correct.
Okay, so tell us about let's just back up before we get into what an MCC exactly is. Hear a little bit about the history of how you two came together around this topic.
I've been working with the working group for a little over a year now. About 2 years ago, I was looking into different initiatives on responsible supply chains, and I read an article, a law review article about the MCCs written by a woman named Sarah Dedouche. And what was interesting is that Sarah Dedouche had some, interesting criticisms, or at least interesting comments about the first version of the MCCs. And she decided that she wanted to really focus on how buyers could put forward their own obligations, which would help ensure responsible supply chain contracts. And so that article that was my introduction to the MCCs was also an introduction to the version 2.0 of the MCCs, because obviously Sue and David Snyder, who was the other chair of the MCC project, read her article and brought her into the fold, as it were.
Oh, absolutely. It was criticism. It was absolutely criticism. And we thought it was so well thought out and so accurate that we needed her to be part of the team. So when we wrote version 1, we always knew that we wanted a version 2. We had hoped for some comments from the legal community in some drafts that we had forwarded long before the publication of version 1. And crickets, we didn't get any response whatsoever. Perhaps people weren't taking us seriously. And then we published version 1 and got criticisms and wonderful comments. And we were able to coalesce a new working group, a new and improved working group that included Sarah and Olivia. And from that new working group birthed, 2 years later, version 2. Actually, 4 years later, probably.
Okay, so that's how this came about. So we're talking about MCCs now, the model contract clauses for human rights. Tell us a little bit about what a model contract clause is and what it's meant to be used for.
Okay, I'm going to jump in for a second. So what happened really was that we realized that corporations had fabulous human rights policies on their website. And some of them were sincere and really wanted those policies to be adopted, and others perhaps were less sincere and liked the ability to have what I'm going to call plausible deniability as to any taints, which is what we call incidents of forced or child labor in a supply chain. So the problem with the wonderful policies is that they were not made operational. There are silos in every corporation between compliance, legal, procurement, and a board. And unless everybody's on the same page with respect to how to implement those human rights policies, it's not going to happen. So in version 1 of the model contract clauses, or MCCs, we turned to reps and warranties imposed on the supplier, and then learned with Sarah Dadush's criticism and some other, actually over, I think 70 consultations with companies, that some of the failures with respect to supply chain human rights really rested with the buyer's insistence on last minute change orders, unrealistic delivery dates, and other terms and conditions that really put such pressure on suppliers that it was impossible to abide by the very same human rights policies that the buyer said they wanted to be in place. Patrick, do you want to go from there to what it is that version 2 does when it abandoned the reps and warranty framework for a shared responsibility framework?
Sure. Let me just ask Kaitlyn, did you have any questions so far about any of the legal jargon that we might have thrown out?
I am thinking our audience might like to hear the different, you're making a distinction between reps and warranties versus shared responsibility. Maybe you could explain that a little bit more before we move on.
Sure. The idea of reps and warranties, and really one key issue is that they're unilateral reps and warranties. It's the traditional approach that companies have taken, particularly in the last 20 years, is to have a contract which says, supplier, you must sign all of these representations and warranties that demonstrate you are abiding by all of the different conditions that we feel are crucial to having a untainted supply chain. So these can often be found in supplier codes of conduct, which are really well thought out documents that include list of the different types of processes and procedures that need to be in place in a company. And then a supplier would almost unthinkingly sign that document or whatever document that says they will abide by those terms. The issue is that can often devolve into a tick box exercise where the suppliers aren't really intent on abiding by those terms, and the buyer isn't necessarily that intent on holding the company to those provisions. So the idea particularly in version 2.0 was to introduce a contractual framework whereby both parties had some obligations, both parties could enforce each other's obligations, and that two-sided dynamic created more buy-in and created a more realistic opportunity that the obligation would be adhered to, such that the parties could actually start carving out some of the tainted products from their supply chains.
Let me explain that commercial law, as we traditionally know it, does not do a good job of distinguishing between soccer balls that are perfect in stitching and color and bouncing and soccer balls that have been made by children. So we don't have in our case law or in traditional contracts a concept that says, no, a soccer ball that's been made by a child is in fact non-conforming, is in fact a defective good, and the buyer has the right to reject it on that basis alone. So one of the concepts that both versions of the MCCs have put in place is being sure that the human rights policies, like the specs with respect to the size and the color and the materials that are going to be used in producing a particular good, that those human rights policies are placed as specs, as requirements for the good that's ultimately presented by the supplier, and can be rejected on the basis of a failure to comply with those human rights policies. And that was a kind of a novel approach, and made the concept of human rights impacts essential to proper performance of a contract.
That's fascinating, the shift. It always fascinates me how much legal concepts and law in general really define so much, or really in a way there's so much power in it, but it's so invisible to most of us. You know, so this is really fascinating. I didn't know that distinction, even though we do, you know, we'll work on the policy on the corporate side, but we're not lawyers, right? So making sure that that gets in the contract is really, really important. And so I'm learning something new. I love it.
Something that we preach oftentimes when we're kind of advocating for incorporating the MCCs or other types of responsible supply chain frameworks is that it's very important to integrate your legal department with your compliance department, with your procurement department, with your, you know, if you have a sustainability department or it's part of the marketing department, but you incorporate all of those different work streams, and so that there's one coherent framework that they're all working towards. And so the foundation are the legal terms and the legal obligations under which the other operators will execute and do business.
And even
go ahead,
preceding the contract, the idea is that the procurement department has to, through human rights due diligence, be sure that the suppliers they choose have the resources to, again, abide by the human rights principles, just as they would do, you know, are they close to some kind of transportation facility to get the goods up to market? Are they close to, you know, a mine if they need some kind of chemical, you know, material? So the idea, again, was to get everybody on the same page to accomplish the goal, which was to reduce human rights impacts as much as possible and acknowledge that they're going to happen. It's not an automatic default and then we're going to terminate the contract. That's not helpful to anybody. What we really need to do is get in and remediate, make sure that particular problem doesn't happen again, and maintain relationships, because that's good for the entire community.
So interesting. So tell us a little bit about application and in practice. Do you know of companies that have been putting the MCCs into practice? Have you heard any feedback from the community, that the legal community that might be using these?
Me too.
Well, one thing I'll just mention, and I'll let Sue go on, but an important point to underscore is that these are modular contractual terms. So there's a template that's set out which lists a series of clauses. These clauses allow for things like human rights due diligence. So that's investigating your supply chain and ensuring that their issues aren't available. And then remediation of those issues. I think Sue mentioned remediation earlier. That's when you discover those issues, how are you addressing them and resolving them, remediating them? And Sue mentioned, you have to be in a position of believing that you are going to find issues. If you're conducting human rights due diligence and you have a operational level grievance mechanism that discovers no issues, then you probably don't have a well-functioning mechanism, because the supply chains are too complicated these days. And so how do you realistically address those issues? How do you incorporate those issues? So that's one point. And then the MCCs, being that they're modular, some companies can decide to focus on remediation or human rights due diligence or specific responsibilities that they're willing to take on or that they really want to ensure that their suppliers take on. So that gives you a sense that different companies are taking different things from this approach. But I'll let Sue go on to talk a little bit about the implementation as well.
No, so I'm glad that Patrick stressed the modularity of the contracts, and we know that so we've talked to I can't even imagine, 50 different companies in the course of the last 18 months after the publication of version 2, and companies even before, when we were just talking about the more traditional reps and warranties. And we know that counsel has suggested pieces, if not the entirety, of the MCCs to clients. In addition, we've been thrilled to agree that the Association of Corporate Counsel, which I think has over 40,000 members, has put our clauses on its website behind its paywall. And they've asked us to prepare a 6-modular training session for the attorneys that are part of that. So we cannot reveal particular names of any clients that are using the clauses, just as we couldn't the names of any clients. But we've been we're actually shocked almost by the reception of the clauses, especially I think since the uptick in the Customs and Border Protection, CBP, enforcement of the Uniform Forced Labor Prevention Act, which is UPLA. We just learned a new way of referring to it on Friday. So there's been more and more goods that are withheld at our borders because of tainted labor in the last 2 years than ever before. And as the CBP enforcement increases and additional enforcement looks like it's down the road, along with the European directive laws that are in this area, we've gotten some real attention to the model contract clauses from companies and counsel that are looking ahead.
Yeah, I just wanted to add a little, just a bit of texture to that point. We've spoken with some companies about the MCCs, and they'll say something to the effect of, I really appreciate this approach. We would really like to incorporate this into our contracts, but to be honest, we need some type of entity above us forcing us to do the right thing, forcing us to put these contracts in place, be they consumers, investors, or regulators. And what you're seeing now is a confluence of all three of those. We've had the consumers who are becoming more and more savvy about these issues. We're seeing more and more investors incorporate social issues into their ESG ratings and into their assessments of companies. Those are obviously important, but the main thing that Sue mentioned is the Uyghur Forced Labor Prevention Act and the other actions taken by the U.S. government and other governments to remove products that are tainted by forced and child labor from supply chains. And it's effectively been a wind in our sails over the course of the past couple of years, really allowing us to push the MCCs so that we can explain this isn't something that's just a voluntary, useful, aspirational goal for you to have. This is one of the best ways that you can ensure you're in compliance with the evolving regimes that are coming from the US and other countries. So Sue mentioned the EU due diligence regime, which is a proposed EU directive that will be EU-wide, requiring companies to incorporate human rights due diligence into their supply chain practices. There are already several countries in the EU, including Holland, or I guess the Netherlands, Britain, France, Germany, that have some version of due diligence laws. And then the US has recently brought into effect the Uyghur Forced Labor Prevention Act, which effectively prohibits products that have any nexus to the Xinjiang region of China or to Uyghur forced labor in general. It effectively prohibits them from entry into the country. Just to give you a short background, if you don't mind, shall I go on?
Yeah.
Just a very short background.
Absolutely.
Since the 1930s, products produced using forced labor have been prohibited from entry into the U.S. But for a large part of that time that law was on the books, that's Section 307 of the Tariff Act, for a long time there was a carve-out called the consumptive demand carve-out, which effectively nullified that act, or at least provided such that there wouldn't be very much enforcement from the U.S. Over the past 5 years, that consumptive demand loophole has been removed, and the U.S. Customs and Border Protection Department has been actively enforcing that prohibition on forced labor. So they've been issuing what's called withhold release orders, or WROs, and those WROs will say, they could say a particular product from a particular company, or a particular product from a particular country, or some variation of that is effectively prohibited from entry. And so if you have a shipment of that type of product from that type of company or country that's subject to the WRO, you would have to demonstrate that it's not actually produced using forced labor. So that's the WRO standard. And on top of the WRO standard, they've issued effectively a massive WRO called the Uyghur Forced Labor Prevention Act, which effectively says if your products have a nexus to Uyghur labor, if they're subject to the act, then we have a rebuttable presumption that those products have been produced using forced labor. And the rebuttable presumption would require a company to produce clear and convincing evidence that its products weren't produced using forced labor. But the issue is, attaining clear and convincing evidence to meet that standard is incredibly difficult, particularly if your products are produced in that part of the world. So the Uyghur Forced Labor Prevention Act has been on the books for about 3 months, and no company has yet tried to rebut that presumption. All the companies have been doing, what the companies have been doing is trying to demonstrate that their supply chains don't touch that region of China. So their supply chains, that their shipments aren't subject to the act. But even to do that, you want to have clear, ongoing, reliable information and communication from your suppliers, because it's not just your tier 1 suppliers. You have to demonstrate that the components and subcomponents that are included in your product aren't subject to the act, don't touch Uyghur labor, or don't touch Xinjiang region of China. So to get that reliable information from your suppliers, it helps to have a contractual regime that puts the framework in place for that communication. So I hope that wasn't too long-winded, but I wanted to give you a sense of the issues that we're working with and why the MCCs are even more relevant, especially relevant today and going forward.
No, I thank you for that. I think it's incredibly enlightening. And again, we were talking about this earlier. I can't remember if this is on or off camera, so they can cut it out if I'm repeating myself. But you know how much law, underlying law that we're completely unaware of as consumers really drives the products that make it into our homes. So I'm actually shocked. I did not know about the carve out under the, you said Tariff Protection Act? What was it?
The Tariff Act.
So there's the Section 307 of the Tariff Act of 1930 prohibits forced labor products.
But we
then
basically made an exception.
Consumptive demand carve-out said something to the effect that if there's a problem supplying that product in the U.S., that those products wouldn't be subject to the act. Something along those lines. I'm not sure exactly what the term was, but it effectively carved out a loophole that allowed for globalization during the 20th century, which didn't have a issue with products produced using forced labor or child labor.
Wow. Susan, I think you have something to add to this.
No. So I thought Patrick's comments with respect to sort of the evolution of some of the underlying law, it was really essential. And I just wanted to sort of, tie that into the MCCs, and that the MCCs do have a comprehensive reporting and ongoing due diligence mechanism, so that you would have that clear and convincing evidence from the very start, even before any questionings might come up before the CBP. And that if questions did come up, you'd be able to say, oh no, we're clean as a whistle, and here's all the proof. And it could be either quarterly or monthly. Again, that's up to the contracting parties, but the MCCs provide specific language requiring that kind of ongoing documentation, which will be key.
I think
Just to supplement Sue's point and kind of to illustrate a bit how there are all of these different work streams that work in concert with each other. So the MCCs might be incorporated in your contract to allow for ongoing document collection and recording and reporting and things like that. I've spoken with different companies that provide for supply chain due diligence tools, and they've found that the companies implementing those tools don't request that every contract have your supply chain documentation running through it. Rather, what they do is call for periodic or test cases, which demonstrate the documentation, demonstrate the supply chain flow, for instance, for you to assess whether or not your supply chain is subject to the Uyghur Forced Labor Prevention Act. And rather than having every shipment be documented, you teach the supplier to assemble those documents such that if there is an enforcement action, you'll know the information, you'll be ready to go. There's a coherent practice. So the procurement people work with the legal people to have a system in place.
That's great. I'm still just reeling over the fact that we basically allowed, just explicitly allowed forced labor and human rights abuses for our growth as a country. It's just, I mean, you knew it happened, but I did not know there was actually a legal allowance. It's shocking, honestly. It's really shocking. I guess I shouldn't be shocked.
Yeah, it's basically imagine a law that says you're not allowed to cheat on your tax returns, but the IRS just hasn't been enforcing it for 75 years.
Wow.
Well,
I want to hear from you next, please.
No, I guess I so want to weigh in terms of best intentions and an evolving sensitivity to these issues. In that we now recognize to a degree that I don't think was true historically, that all of our economies are interrelated. So I'm going to go back to that concept of plausible deniability. I think many companies knew that there was forced labor in the supply chain. I've actually talked to people who have worked for companies and went to Thailand and were visiting all of the, fabulous factories and plants and saw the 2 or 3 or 4 that were fenced in with young women that were indentured for 2 or 3 years. But it's awfully difficult to enforce without being ugly American our cultural norms on other countries. And that was and remains one of the tensions even today. So I think one of the big differences about the working group and the responsible contracting party project is that we don't want to adopt the same tone as NGOs, non-governmental units, and civil societies, and be accusatory and say to our clients or these companies, you've been really bad and you can't be bad anymore, and you're going to be held accountable and liable. Instead, what we really are trying to do is come up with some concrete tools that help everyone get to the right place, which is doing away with modern slavery in a cooperative and collective manner, without suggesting that we have a higher moral ground. That's really important to the business law section and the working group in particular. And I think that is our MO.
Thanks, Sue. Thanks for making that point. I often say these aren't ghouls that work for these companies. Yeah. People are trying to do the right thing in the context and the confines of what they're doing, but these are complicated issues. And you're talking about supply chains, particularly when you get to tier 2 and tier 3, where there isn't that much obvious leverage that a U.S. company buyer might have over the second and third tiers of those supply chains. So the idea of the MCC project was to provide tools for these companies that want to do the right thing. And the point that I was making earlier is not only now do companies want to do the right thing, they almost have to do something more proactive.
Right. Which certainly helps us convince those companies that the time is right. This is the moment. Yeah.
Well, and sorry, just to put a bow on that, there has been an approach taken over the course of the last 20 years. This has been an issue that's been more and more prevalent, and companies have instituted policies like these unilateral reps and warranties, these supplier codes of conduct. The problem is that we've found over the course of the last few decades that those aren't sufficient to meet the challenge. And so now we have to think through new tools and new approaches to meet this challenge.
Yeah, well, it sounds like a wonderful tool. Where can people find the tools? Are they freely available?
They're freely available, and there's even a Word format, so you can download, cut and paste, and get started. So you could find them on the American Bar Association Center for Human Rights. They've been published in something called SSR, and I don't know what the acronym. That's a scholarly publication. I don't know what it even stands for, other than scholarly. I'm sure is in there somewhere. It's also on the. It's been published within the Business Lawyer, as well as Business Law Today, which are both American Bar Association publications. And if someone is part of the Association of Corporate Counsel, which again is a sort of a membership or trade association of general counsels for corporations, you would be able to find them on that website as well. Any other places, Patrick, that you know of?
No, I was just going to say, just to make it easy on you, if you Google ABA model contract clauses, the main website should come up, and that provides a few different resources. So it gives you an executive summary, which is really helpful, as well as an introduction, plus the full report on the model contract clauses, which gives you the full set of document and explanatory resources on those clauses. Mm-hmm.
So, we'll include links to those in the resource boost for this episode, so our listeners can just go click away. But I like to ask everyone to make sure that they're freely available. Sounds like a wonderful resource, and it's one of those things that you continue to learn more about each of these issues under E, S, and G, which is a list of hundreds of issues, right? The human rights in the supply chain, and forced labor in the supply chain, or modern slavery, as you called it. So, it's obviously a much bigger problem than anyone sees or hears about in the U.S. in particular. But probably true in a lot of places where most consumer goods are made elsewhere. So I'm really glad that we took a deeper dive on this particular issue today on the podcast, and so happy to have had you on.
No, again, thank you so much. And be on the for coming attractions. There will be a version 3, which will incorporate some software and blockchain technology in the clauses, and probably a version 2.1 even before that, which is going to fold in better in the environmental pieces. We're working with the Chancery Lane project for that. And there's also a civil society or European version that will be coming out probably in the next 6 months.
Oh, see, that's wonderful. And so when is the third version? You said there's a 2.1 and then the V3. So what's the timeline on those?
I think V3 is, I can't imagine it happening in less than 2 years at best. Okay. So that's going to be, that'll be that's a project that will follow the European model clauses, and the 2.1, which will be the environmental, and some corrections or reassigning of the provisions to make it a little bit more, to flow a little better. So some corrections to version 1, 2.
Fantastic. Well, we can't wait to see what you guys come up with next, because I know these are great tools, and we talk about being actionable on this podcast, and I feel like this is an episode that's especially actionable. Folks can literally go download the clauses, share them within your corporations and within your firm, start adding them to contracts. It's literally something we can all do today to make a big difference for the people that make all the things that make our lives so convenient. And so, yeah, it's simple and actionable, and I love it.
Yeah. Let me just add, and members of the working group, we're lawyers and professors and practitioners in this area, and we'd be happy to talk with any companies that are interested in incorporating the MCCs, but need to kind of think through some of the clauses and the implications of the clauses. So that's one point. We're definitely reachable. And then the other point is just about actionability. Even if you're maybe a bit intimidated from incorporating all of these clauses into your contracts and solidifying them tomorrow, the main approach that governments are taking around the world and companies are taking is to first focus on human rights due diligence. First, just understand your supply chain, see what the challenges are, and don't think that you have to boil the ocean. Don't think that you have to clean up every bit of your supply chain tomorrow. Think through what are the key products that might create risks that your company is contributing to human rights abuses, and address those first. And you don't need a contract to do that.
Prioritize, yeah.
Right. Totally agree with that, Patrick. Good point.
Yeah, I think when we look at the scale of some of these problems, it can feel overwhelming, analysis paralysis, and oh my God, how do we stop? This is horrible right now. But you're right, in the reality of how things work in the world, just at large, it's prioritization is very, very important. So I think that's additional helpful context there. Any other closing thoughts you'd like to share?
No, we just are very.
No, thank you for doing this work. Thank you for having us on. We're really hoping to just evangelize about the MCCs and work with really smart people. And we're really happy that ClimeCo is able to sit with us.
Give us this format. Absolutely. Yeah. Thank you.
Thank you both so much.